democracy and the rule of law. With me on the show this evening is Barrister Obiora. Barrister Obiora, welcome you to the show this evening.
Thank you very much, and a very good evening to our esteemed viewers.
And also with me is Barrister Michael Mana. Barrister Michael, welcome you to the show this evening.
Thank you, Kenneth. Good evening, viewers.
Alright, without wasting much of our time, we'll just dive into the topic for today. The presidents have signed the instrument of clemency and pardon to deserving inmates, deserving in quotes, because some of the inmates, some of the names that appeared in the list that we saw previously after the outcry by Nigerians, have been withdrawn, and another list has been released. So can you run us through, some have even expressed, some of them were murderers, some of them drug traffickers, some of them, some of them with a lot of capital offenses, who found their way into that list. Can you run us through the process, of this presidential pardon or clemency?
Thank you very much. The issue of prerogative of mercy and the power of the president to grant pardon to a convict or someone undergoing criminal proceedings or trial is not new in our jurisprudence. It's been there over the years. We inherited it from England, and in fact, the history of the prerogative of mercy dates to the ancient Greek and Roman periods. It started when those in authority felt that there was need to allow people who are committed offense to the order, looking at the peculiar circumstances, to be pardoned, either absolutely or conditional pardon. And over time, that one got to Britain, when Anglo-Saxon England, when Henry VIII, also exercised that power. And of course, William the Conqueror also in schools included the power to pardon. And then the United States equally got it when they drafted their constitution, because they were already aware of the provision for clemency in the British law. Now, in ancient Rome, we also saw as an example where Pontius Pilate, who was a ruler at that time, granted pardon to Barabbas for purpose of pleasing the people, because the people demanded somebody be released, and Pontius was willing to release Jesus, but they said no, give us Barabbas, and that was so. The issue now is this: what are the reasons for exercising this clemency? And the extant laws we have in Nigeria, is it the same thing in other jurisdictions? What are the ways this power of clemency is being exercised in other jurisdictions or other crimes? Is there a way we are getting it wrong? Are we supposed to do certain things to make it more transparent, more in tandem with the wishes and the morality of the nation? In Nigeria, we have seen instances of prerogative of mercy, that of the late Alamesia, who was convicted of money laundering and later pardoned by the former president, Goodluck Jonathan. There have been other instances, and this thing is a constitutional provision. It contained in Section 165 of the 1999 Constitution as amended, which means the president has the powers to pardon. But then, one thing is clear: the type of offenses that this power of the prerogative of mercy is to be exercised on is still an issue that is still subject to some discussions, some controversies, some disputes. Some have opined that yes, the president has the powers to pardon, but he is not expected to pardon people who have committed grievous offenses. Offenses like murder, offenses like drug trafficking, offenses that hit at the very fabric of society. And in other crimes, like in the United States of America, what happens there is that the president will grant conditional pardon. He could say, this person is to be released on condition that he pays a fine. It could be a pardon. But the nature of the offense and then the chances that the person may have changed, is always a determinant factor.
Yeah.
But we look at the list of the persons that were the beneficiaries, the first list of the one done by our president. Some people subjected to a kind of clinical analysis and came up with the fact that drug-related offenses, convicts were, more in that list. Other serious crimes were there and so on. And the question was whether, this is another way of encouraging criminality. That was what came up, and there was a public outcry. Nigeria rose up and said that though they don't deny the fact the president has the powers under the constitution to grant pardon, but it must be done in a way that the very fabric that holds us together is not destroyed. And it may be destroyed if people are giving strange reasons or alluding to maybe special interests in the names of those that were pardoned. For example, a particular lady that murdered her husband, she was pardoned. And you see, it's always the case in two people having interest. The group that represents the family of the husband say, no, this lady killed her brother in cold blood. And the court has already sentenced her to death. And that is what will meet the demands of justice. Anything less than that will appear to be injustice. And that the blood of the disease is still crying for justice. On the side of the family of the woman, the convict, their own argument is that, yes, they know that their daughter killed her husband, but they had children between them before the incident happened, that it is better to allow the woman to be alive and take care of the children. It's an argument that can go on and on and on. But one thing that appears clear is that Nigerians were not satisfied with the list of those who were meant to benefit from this mercy, prerogative of mercy. And that made the president to withdraw the first list, and then we were made to understand that some names were smuggled into the list. And the president has now, by way of directive, ordered that the committee that handles this be moved to the office of the Attorney General of the Federation, so that in future, before names are listed, there will be proper checkings and everything seems to be done properly. All right,
Mr. Mike,
yes.
Obviously, this one was a very, very long one, and the Nigerians, they need to cry, because when we talk about the presidency, we ought to, the excellency of the country ought to rest in that office.
Very
and
well.
The way things are done.
Sure.
Right, because that represents the whole image, how we are perceived both locally and internationally.
Yes.
So are we supposed to be getting this, given how serious it is, are we supposed to be getting it wrong?
Thank you very much, Kenneth. You see, when I read about the withdrawal of the first list and then substitution, I felt some sort of disbelief, because there are some things that the president is expected to do and then never to go back. You see, the constitution has actually given the president, this section 175 subsection 1 says any offense created by the National Assembly, any person that is convicted of any offense created by the National Assembly, the president has the right to pardon that person. Section 1. I mean, that's 175 subsection 1. Now, it is immaterial the type of offense that the person has committed based on the constitution, and the president can actually pardon. But before the president can pardon, subsection 2 of that 175 says the powers of the president under this constitution, under subsection 1 of this constitution, shall be exercised by him after due consultation with the Council of State. After due consultation with the Council of State. It is after that due consultation with the Council of State that the president can bring out the list to the public. Now, do we mean that the president did not consult with the Council of State when the first list was released? Is that the meaning? Or does it mean that after, because if you read the release by the personal advisor, he said that the press, he says that it was after due consultation with the Council of State.
Yeah, obviously.
Yes, that means that the first list was not with due consultation with the Council of State. This is a very sensitive issue that the president should not tinker with. You realize that we have had presidents in this country. How many of them have ever issued prerogative of mercy? Very few on political issues and all that. But when you issue prerogative of mercy on people that had killed,
at least we are more than 100 and something,
and people that are drug traffickers, you are actually sending a signal to the world that these people they like to tolerate such offenses, which is very inimical to Nigeria. Now, since the president had committed this, I don't want to call it blunder, because but he has done something that is he has done something that is not supposed to have been done, and he decided on his own to withdraw, to call back the list. And then, according to the release, he has also removed some names of people that committed serious, grievous offenses that made the president to be seen as being insensitive to the yearning of the society. Because
to remove the name, with those people whose names appeared there, would they have right after?
Well, the truth of the matter is that it's a prerogative of mercy, and you cannot go to court to challenge the president's action. That is one, and you are not entitled to the to the pardon in the first place. So if you complain that but the president pardoned me, now he has he has retracted the pardon, and then I'm going back to prison, you are talking to yourself. That is the truth about it.
Does it mean that? Sorry, let's get it. Because I want to clarify.
Very well.
Does it mean that, for instance, those Jonathan pardon, does it mean that this president can recall it back? Because for your
no. He cannot. The president had the president had already pardoned those ones who can't. It's not something
that he has pardoned now. He's recalling.
That's why I'm trying. That's why I'm faulting the procedure. I'm faulting the procedure now. You see, the procedure is that you must consult with the Council of State.
Yeah, but they said they did consult, because at the time they released the first list, that was the same time they confirmed the INEC chairman in conjunction with the Council of State, because some of them, in fact, they said that some of them didn't come to that. That was the same time they released the first list, and at the time they confirmed the INEC chairman.
If they had confirmed this release consulted with the Council of State, and then the list was confirmed, the president has no power to withdraw that list again. That is my own legal understanding of this. Now, the second thing is that the law, the offenses that were created by the National Assembly are the only offenses that the president has the power to pardon. Under Section 212 of the Constitution of the Federal Republic of Nigeria 1999 as amended, the governors have the right, under the laws that are created by the house of the different houses of assembly, to pardon. So if we look at the offenses that these people actually committed, were they limited to the offenses that they were charged under the ones that were created by the National Assembly? For instance, the person that committed murder in a particular state was charged under the state law, the criminal code that was made by the House of Assembly there. Does the president have the power to pardon under that law? No. That is the exclusive jurisdiction of the state governor. So there are so many issues that arose from this prerogative of mercy that one has to really look at them critically. The president has said that he has relocated the office of the prerogative of mercy from the Special Duties Commission to the Attorney General's office. With due respect, it does not matter where the location of the office is. The proper thing to do is proper consultation. If there's no action the president is expected to take without taking consultation from consultation from the Attorney General, because he's the number one legal advisor to the country. And so anything you want to do, you have to consult him and ask him, is it correct to do it? Tell me the way I should go about it. You are not a lawyer. Even if you are a lawyer, you have an attorney general. The attorney general is expected to tell you, Mr. President, sir, these are the ways to handle this matter. These ones are issues that border on the sensitivity of Nigerians, sensibilities of Nigeria. Even those people that actually made it possible for these offenders to be convicted, their spirit will be waned. You bring down their spirit by just releasing those people like that, after some of them stake their lives to ensure that they were arrested, they were prosecuted. So there are so many things that you have to take into consideration when you are exercising this kind of right under the Constitution. That is why I say that the president actually moved in this particular one. He withdrew a list that he had already pronounced, signed. And when they keep talking to us as if we are not educated enough to know, they say that the president has now signed what did he do in the first one when he released it? He didn't sign, and you are saying he has now signed.
That's the impression given.
It's not right. You are telling the entire world that the president has now signed the previous one that was released today was not signed. You are making us the international community to see us as a mockery of a system.
So it's saying that those people who were granted, of course, they can't challenge, their withdrawal from the list, even though it has been signed before, since it's just a privilege and not a right.
Yes, like the appellation or the nomenclature goes, is prerogative of mercy. It is at the whims and caprices of the president, if I may use those expressions, to decide who to grant pardon, but subject to the limitations imposed by law. One of them is that any offense created by the Constitution is outside what the president can, delve into in terms of pardon. But then, it's not only the president that grants clemency or prerogative of mercy. Apart from the president, the Chief Justice of the Federation equally exercises that power to pardon and release inmates. Now, the
inmate,
judge,
convicted inmate.
Those that
awaiting
trial,
okay, not
inmates,
convicted.
not convicted. Now, waiting trial inmates, the Chief Judge of the Federation, the Chief Judges of the various states do go on prison visit, and sometimes when they see people that have been there for a long time on minor offenses, they have the powers to say go. But then what we are looking at is when the president, as in this instance, grants pardon. Now, those that had their names on the first list, whose name did not appear in the second list, whether they have the powers to go to court, the answer is no. Because Because in the first place, it was not as if they deserve, it's not their right, it's not their entitlement. It was just the president desiring to show them mercy. So, and then the other issue that we also need to explore is, can someone who was granted pardon reject it? In Nigeria, we have never seen such. But in US, it happened. A murder convict who was sentenced to death, the President of America granted him pardon and commuted it as conditional pardon from life, death to life, and he rejected it. Yes, and that's the case of Bola and Perovich.
The man decided to die.
He said he rejected it.
All right, the question is that some people have said that the president cannot recall the lists that have already been signed as stipulated by the law. So the question is, if does it mean that the president, after granting pardon, can subsequently retract? Because you are saying it is a right, it is a privilege,
it's a constitutional
privilege, and not a right by the inmate, and they cannot enforce. So, for instance, somebody that was pardoned and it was signed, and the president subsequently and the person would be thrown back to prison, because I'm sure that the families that want to know the end of this, because the way you have put it is as if the president can pardon and re-pardon or withdraw the pardon.
Well, what happened in the current issue of the prerogative of mercy exercised by the president has never happened, to the best of my knowledge, in the history of this nation, where after a list of people that were pardoned was released to the public, and it cannot release a list if it has not been signed. Now, because of public outcry, then information was released that the names that were on that list were not the names the president intended to pardon. That some other persons included smuggled names into it. Now, let's look at it from one angle. The fact that Nigerians rose out in great number and protested, and the president withdrew that list. On the one hand, I would say commendations to the president for being a listening president. Some other presidents may not listen. They will say, after all, I have the powers under the Constitution to do what I've done. Whether it is right, whether the Nigerians like it or not, it does not matter to me. But he listened and withdrew it. Again, the fact that a list was made public and later withdrawn is not very good for the image of the country. But then, at the end of the day, looking at the current reality, I believe that it's a better option to have withdrawn it, even though it may be, a policy somehow, but it's a better option. Why do I say so? Because those that did clinical examination and analysis of the first list, rated drug-related offenses very high on that list. And that, like my brother and colleague said, sent a wrong signal to the world. Everybody knows the effect of drug. Even the present day Nigerian society, the youths that have taken to drugs, what it does to them is terrible.
Yeah, but apart from being policy somersault, what I want to get,
yes,
we want to get the legal standpoint on this. Once the president has signed a pardon, does he have the right again to now say, I withdraw, whether it's based on public outcry or based on he changed his mind? Can he subsequently change his mind? Because if he cannot subsequently change his mind, that means those people who have been pardoned might have a course of action. So does the law allow him to change his mind?
Yeah, I'm looking at it from the angle that from the information released to Nigerians, the first list, the claim was not signed. And for that reason, the president had the powers to really look at the list again and then finally sign. But let's look at it that, assuming the first list was signed, but the people had not been released. The list had not been given effect to, because we wanted to have a list.
Yes.
The other thing is to give effect to that list. The first list had not been given effect to. the thing would have been given effect to when the list is sent to the correctional facilities or centers where these people are being housed for their release. So long as that had not been done, the president, under his discretionary powers, can still recall the first list. But after the effect has been made on the list and the beneficiaries released, it will appear to be an injustice and an abuse for the president. After someone has been released, is already jubilating that thank God is finally out, and then you get the person back to the correctional facility. So I believe that, looking at the circumstances, yes, it may not be, very commendable that a list will withdraw, but then because it has not passed the test of, effectualization, then I believe the president could, in the circumstances, do it. If not for anything, at least to show the entire world that Nigeria is not tolerant of drugs, is not tolerant of corruption, is not tolerant of money laundering, and other high-profile offenses.
All right, we are almost out of time. We just have 2 minutes. So, Barrister Mike,
yes.
In your view, does the president's action strengthen or weaken public confidence in our judicial system?
Well, when you say
we see that the number of people who were pardoned were quite large.
Sure.
There were more than 100 and something.
Very well. You see, this kind of action should not be taken in a hurry. It is an action that has to be weighed with the feelings of society. And that is why I was saying that when the president decided to pardon people that committed grievous offenses, the people that went through a lot of hardship to get them convicted, to get these people arrested, investigated, and everything, will feel bad that they even put their lives at stake to be able to get these people convicted because of the society, to sanitize the society. And so when you do that, even the judge sitting over the matter, hearing that after reviewing all the issues that culminated in the conviction, will feel bad that after doing all this, the president has now said this man should go free. So it sort of makes the people to feel bad about their ability to perform very well. So, but you see, my colleague has said that is it not better to listen to the society than to stick to legal gymnastics? so because ordinarily, if you look at it legally, if the first list that was released was actually signed, the president does not have the right to retract it. But if it was not signed based on what we are reading, then he has a right to recall, and these people were not actually released in the first place. They were still there in prison. Yes. So that is a good thing about it. If they were released, it would have been a different thing. In fact, some of them would have gone underground for you to get them back to prison. So,
yes. Then, before we sign off on this, there is still need for our law to be made more clear as to the determinant, the things the president need to consider in consultation with the Council of State in determining what kind of person, what kind of offenses, deserve prerogative of mercy.
Yes.
All right.
So that we don't give negative impressions to the entire world.
All right. We'll go